you're putting in a lot of effort behind the scenes to build that brand and otherwise get that reputation and that they associate and trust. And yet, how do you capture that value? A lot of it is, it's not tangible. It's not something you point to. And that's where you'd have, as an example, a trademark that comes in and says, if I establish this brand, I own that, that name of the company or product or catchphrase or logo or whatever that might be within the branding. And if somebody were to come along and try and write off those coattails, leverage what, all the brand equity that I put into that, then I have a recourse to stop them, or otherwise, or require them to pay me compensation or get a license. They can still buy it after you've registered your name, and generally don't have a lot of rights. So most of the time they're separate. Me owning a domain name and you having a trademark is two separate pieces of property. You can own you can own a domain name and not have the rights to the trademark. You can have a trademark and not go or get a domain name. So you have to really operate and treat those as being separate. Now, most of that is going to be either the name of the company or the business, name of a product, catchphrase, or logo. 95% of that is where your branding is going to lie and what you're going to look to protect.
Hi everyone, Rob Ratliff here at the Entrepreneurial Odyssey podcast, where we talk about entrepreneurs and their journeys, and they share their stories, their successes, their failures, and all of those things in between. And today I'm here with Devin Miller from Miller IP. He is an attorney who helps you with trademarks and patents. And I was so interested to have him talk to us a little bit about what that looks like. So if you've ever thought about something that you're inventing or trademarking your name, he's going to help answer those questions as why you would, why you wouldn't, when you should, when you don't need to, and then talk about that whole process. So welcome, Devin. Thank you so much for taking the time to meet with us.
Great to be on. Looking forward to chatting with you, and thanks for having me.
So before we get into that IP process, how's and why and all of those good things, just talk to me a little bit about how did you become an IP attorney and a patent attorney? What led you here?
Yeah. So background is undergraduate. I studied a couple degrees, both Chinese as well as electrical engineering. And so, the primary focus was on the electrical engineering side of pursuing that as a career path, and kind of as I was getting to the end of the career path with electrical engineering, I kind of looked and said, hey, I like engineering, but I don't want to be an engineer, in the sense that, the typical engineer, you're going to be working or being a small cog in a big wheel. You're going to be working on one project for an extended period of time, and you really have to, work your way up to the career or throughout the career for quite a few number of years before you ever have any say or impact within the business or within the projects you work on in any direction with the company. And so kind of looked at that and said, hey, really not overly interested in, doing that as a career path from that perspective. I said, kind of what are the other options or the things that would be of interest? And one of them was, entrepreneurship, startups, small businesses. And the other one was more on the legal side of doing more patents, trademarks, copyrights, and, kind of intellectual property, where you work with a lot of startups and small businesses and help them from the legal side. And so with that, I kind of looked at it and said, hey, which one's more of interest? And rather than choosing one or the other, I ended up kind of splitting or going down the middle and doing both. So I did both. I went out and did a dual graduate degree and got a MBA as well as a law degree. And really from that, I've done a number of startups, small businesses. Some turn into or small and continue to be small family businesses. Others are 7-8 figures, and had some exits on those. And alongside of that, always been doing the legal side of being an attorney as well. So that kind of, set me on the looking to go down the legal route. And I've been a full-time attorney and do that, as well as also been a startup and small business owner myself.
Right. Yeah. So, it sounds like in a lot of the entrepreneurs I talked to, they looked at the corporate path and they just said, nope, not for me. And so they went down this other road and they just said, I want my freedom. I want to decide how much I earn and not have somebody else tell me what I'm worth. I think that's absolutely awesome. Were there times along that journey where you just looked at this and said, man, is this going to be more work than it's worth? Or did you always know, this is going to be amazing, I'm just going to keep going?
I think that overall most of it was, it's going to be amazing. Here we go. Now, On the law side, so I've been an attorney for about 11 years. For about the first 5, 6 years, somewhere in there, the of the career path, I worked for some large law firms. So I didn't start out with my own law firm. Part of it was didn't have the experience, didn't have the background. Also, and looking to get some from the legal being an attorney aspect, not probably as much from the business side because most attorneys are terrible at business. But that from the how do I do the practice, how do I do patents and trademarks, and what are best practices, and getting kind of guidance from those who've been in the field longer. I went and worked for the law firms for about 5, 6 years before deciding, hey, I'd rather kind of have the own or my own or captain my own ship, do the own or my own thing, go down the entrepreneur side on the legal side, which is what I'd already been doing on the business side. But it's one where most of it's I think that there's a myth or a misconception that you're more secure, you're better off when you're working for a large law firm or any business, a large company, or someone else as your employer because gives you that false sense of security. And in reality, you can get laid off just as easy from someone else's business as your own business can go under.
Yeah.
It's all a business. It just depends on who's running it. And so from that perspective, I always looked at it as I can either captain my own ship, take my own direction, and do my own thing, and have a be able to do the things that I think make sense to me. And some of when I look at the legal arena, some things they make sense as to why people do it, and others they just do it that way because that's how it's been done for a long period of time, and that's a tradition, even though it doesn't generally make sense or it doesn't resonate with me. And so that was kind of where I said, hey, I'm either I can let someone else run the firm and kind of at the whims of them, or I can kind of go the direction I want to go, have more control and say, and the risk is probably going to be comparable either way I go. So that was kind of, in a nutshell, kind of went through in a much more extended version, went through that analysis and decided to go on or start the law firm and go down that route as on the business or of starting the law firm.
Well, and I've worked for corporations myself, bigger businesses, smaller businesses, and the smaller businesses sometimes they get started and they fizzle out. Some of the bigger corporations, they'll just there's been some where they've been purchased by other big companies, and then now I'm out, back looking for more work. And I think it was one point in my life where I just decided, there's one person that I know I can depend on to keep making me money, and that's me. And so it was just, for me, that was that epiphany where I just said, I just need to go in business for myself because I know I can always keep myself busy. Where if I put my job and my income in the hands of other people, you just never know when you're going to be out on the street looking for more work. So I can imagine it was the same kind of thing you're thinking as, now it's time to go off on my own because I know that I know what I'm doing. I know how to get business. So might as well do it myself instead of depending on someone else. So awesome bar.
Yeah, not the one thing that I always have to laugh is, it's one where you have to steer or steel yourself, so to speak, of when you tell someone else you're starting your own business, is you get a unique reaction. It's generally interesting. You tell, and I can't remember, it's not my original thought, but it was or reading it or saw it somewhere, which is, you tell someone that you're starting or working for a startup, there's a level of excitement that's awesome. They want to know all about it. You tell someone you're starting your own business, and then it's much have you really thought that through, and is that going to work out? And do you know how most businesses fail and all that? And so you can be working for as risky of a startup, and people are excited for you and generally are encouraging, and you start your own business, and there's a lot more detractors. Typically, there's always
Right.
exceptions, but so stealing yourself for having to not or to have to be your own internal support system, maybe have a spouse or a mentor or a business partner that, but overall you're going to have to be anticipating that you're going to get some of that feedback along the way.
Yeah, you just have to know that those naysayers, even if they've been in business and failed, it doesn't mean that you're going to fail. So you just gotta persevere, keep through it. But I love that idea of just saying, yeah, I'm working for a small startup that does, this or that. That's a pretty cool way to say it. I want to touch a little bit about let's talk about the trademark side of things. Why is it that trademarks are important, and how do you know when you need a trademark?
Yeah, so and I'd probably back it up just a little bit if I could or if you
Sure.
look at kind of intellectual property, what is it or what does it encompass? And I think it will hit on yours, but when you're when somebody is generally referring to intellectual property, it's an umbrella term that can include patents, trademarks, and or copyright. So it's kind of all encompassing of that overall concept and idea of owning something that's less tangible and yet still has value. And so when you look at it, patents are going to protecting an invention, so an innovation, something that does something, it has a functionality. Trademarks are going to protect your branding, so name of a company, name of a business, catchphrase, logo, name of a product, those type of things. And copyrights are going to protect something that's more creative in nature. So a book, an image, a photo, a picture, a video, a podcast, a number of things on the creative nature, you can have or have those covered on their copyrights. And so kind of within that, the reason why, whether it's trademarks or patents or copyrights, the motivation is still the same, which is, when you create, a lot of what you're trying to capture is that value, the time and effort that you're driving into that. So building a brand, if all I do is come up with the name of a business and never do anything more, has a pretty minimal amount of value to it. But if I go out, I do, whether it's SEO and have a great website, or do, establish a reputation with businesses and do B2B or I get a great brand and people start to, grassroots movement, or, organically start to get excited about that. You're putting in a lot of effort behind the scenes to build that brand and otherwise get that reputation and that they associate and trust. And yet, how do you capture that value? A lot of it is, it's not tangible. It's not something you point to. And that's where you'd have, as an example, a trademark that comes in and says, if I establish this brand, I own that, that name of the company or product or catchphrase or logo or whatever that might be within the branding. And if somebody were to come along and try and write off those coattails, leverage what, all the brand equity that I put into that, then I have a recourse to stop them, or otherwise, or require them to pay me compensation or get a license or otherwise. And so it's really kind of about capturing that intangible, and that's why it's intellectual property, something that's intellectual, intangible, that kind of property that of when you're putting in that time and effort to build or in that value to it, that you have a recourse so that businesses have a motivation to put in that investment and not hold back out of fear of not being able to capitalize on it.
Yeah, that's well said. I think about terms. These are just things going back in my memory where I've talked about things like jacuzzi. That was kind of a trademark name, but maybe not protected enough because everyone just started calling every hot tub a jacuzzi. And I think now we just kind of call it a hot tub. Is that a true story? Like, did they have a trademark? Did they not have a trademark? Did they lose a trademark because they didn't hold on to it tight enough? Anything about that,
I'm
or how
going
that might play
jacuzzi.
out?
That one I haven't heard before. The one that I do know that comes up often is on Xerox. And now
And it might be
Xerox,
that one, yeah.
people don't make a copy as much. It's probably fallen out of favor. But for a long period of time, when you're going to say you're going to or make a copy of a paper, you're going to just say I'm going to Xerox it, even if you weren't using a Xerox machine.
Mhm.
And so on occasion, if you become such a generic or generically used term, or everybody refers to that, it loses its ability to associate with a brand. So trademarks are generally, hey, when I hear this, word, phrase, see that logo, I know it's coming from a brand. And what you're referring to is what's called genericide, which is it's become so generic that it loses that brand identification, and people really don't associate it with the brand anymore. So that happened with Xerox. It also happened with Kleenex. And, in other words, when people hear, hey, can you hand me a Kleenex? It's
Right.
really, that was a brand. And yet
Yeah.
most of the time you're just referring to a tissue. So
It's a
that
Western
can't
family
happen.
box, but it's a Kleenex inside there.
Yeah, and it doesn't, from 99% of brands, it doesn't happen. You never reach that level of being that generic, and people don't, you don't have that level of association with a given product, but it can happen on occasion. Google is always fighting against that because a lot of people will say just Google it, which really just means do a web search now. Google pushes back and is very assertive on their branding of saying, no, you're doing a web search or you're searching the internet. And so they are working, heavily to avoid becoming generic in that sense, because you can learn from kind of the other or past issues that other brands have face. But it is one where most people, you don't have to worry about it. But if you do reach a level of infamy or fame, that you have to make sure you guard against that.
So how would I know as a business whether I should trademark a name or a service, or what can be trademarked, I guess, is the real question. And how do I know if I should or shouldn't pursue a trademark?
Yeah, I mean, really, anything that is associated with your brand almost always can be trademarked. Now, most of that is going to be either the name of the company or the business, name of a product, catchphrase, or logo. 95% of that is where your branding is going to lie and what you're going to look to protect. You can technically, other off the wall examples, there is a trademark for the smell of Play-Doh, has a unique smell. There is a trademark for both for Apple as well as for Microsoft when you boot up your computer and it has the sound that it makes, the bum or whatever that is. Those are trademarks. You'll have some of the football teams that have specific colors for their grass on their stadium that is associated with their football team. That's not just a generic green grass. It's blue and there's a red one. Those can be trademarks. So if you have branding, generally it can be pretty diverse as far as what it can be, but for vast majority of the companies, it's going to be name of the company or business, name of a product, catchphrase, or a logo. As far as when it makes sense to pursue, I'm generally going to look at it as whether or not you've built in enough brand value or equity in order to go after. So at any time you could go after. You can pursue a trademark before you get the business going. And a lot of times, if you're looking to build a business and going to do a lot of pre-work or getting a lot of things ready behind the scenes, and you're going to get packaging or you're going to get branding or you're going to get marketing materials or a website, you're going to say, hey, before I put all that effort in, I want to make sure it's protected, or I don't put that effort in and then all of a sudden have an issue with the brand or having to look at rebranding. But you can do it at any point. What you're going to look at is whether or not it has enough value into the business. And or one, you're going to look at and say, do you have the budget to actually pursue it? You don't have the budget. It's a simple, hey, I'd love to get a trademark. At this point, I just don't have the budget. Then you just simply don't do it. But if you do, then it's going to be, when is the trigger points where you put in enough time, money, and effort that the brand has some value? So if all you've done is put up a simple website, printed a couple business cards, you really probably haven't done enough that you've driven in that value to the brand. And kind of where I always look at it is, I call it the ouch factor, which is if somebody to come along and knock off your brand, or you got a cease and desist letter and told you had to rebrand, would it have an ouch? In other words, would it, if you had to rebrand, there be enough impact on your business? Say, no, that's going to be a major pain point. It's going to be a large loss to the business. I'm going to lose revenue. I'm going to lose all that brand equity. Or you're saying, yeah, that sucked, or wish I didn't have to rebrand and I like the name of the brand, but hey, it'd be a little time and effort, but probably not a big deal. If you're that latter where you're saying, hey, maybe I wouldn't be happy about it, but it wouldn't be that big of a deal to switch brands, you probably haven't built in enough equity to really worry about getting a trademark at that point.
Okay, so you have to have a really good brand, maybe good brand recognition, a good name, or certain logo. I mean, it would be trademark, that kind of thing. But it needs to be something that's going to be pretty.
Yeah, and one thing that or I didn't touch on that, or the other thing is now, a couple things as to whether or not something is trademarkable. So one is whether it makes sense to, from a business perspective, or whether or not you have enough value in there to pursue a trademark. The other is the brand that you're looking to pursue or that you've driven value into even trademarkable. And really with that, there's a couple standards that you're going to look at for whether or not something is trademarkable. So one is what's called confusingly similar. And basically what that means is that if there's already another trademark that's already out there, previously been filed and registered, or filed and or registered prior to you, that if a consumer to look at that brand and they're to look at your brand, would they think there's an association, there's a tie together, there's a relationship, or it's otherwise the same business? So they'd be confused as to who's offering the products or the services. If you have that issue, you wouldn't be able to get a trademark. So if you wanted to go start a shoe company and you did it with Nike with 2 E's, people are going to think you're associated with Nike with 1 E, and you wouldn't be able to get a trademark or use that as branding. If you were the first person to start Adidas, hey, yes, you're selling shoes just like Nike, but they're not going to look at it and say, Adidas is a different word, different spelling, pronunciation. There isn't going to be that likelihood of confusion. Same thing if you went and started Nike restaurants, people probably aren't going to think that Nike restaurants is associated with shoe company. Nike is famous enough. Don't go try that. But the general thing, or the general principle, holds true. The other one, as far as the standard for trademarkability, you're going to look at is whether or not it's too descriptive. So what you're not able to do is if really what you're using a generally used term for product or service is in the industry, you can't go out and trademark it. So I'll give you a simple example. If you wanted to go open up a fruit stand, you wanted to sell the fruit apples, and you wanted to brand your business with the word apple, all you're really describing is a product you're selling. People aren't going to think that's the brand of your business. They're going to think that you're telling them what you're selling. If you go
Right.
start a smartphone company that sells or that's the name Apple, people aren't going to, there isn't going to be that descriptive. Apple is a smartphone has nothing to do with the product. Apple is when you're selling the fruit is going to be too descriptive because you're just describing a product or service. It doesn't really, or it's not really conveying any brand value. So those are kind of the two standards that you look at. So one is, does it make sense to pursue it because you've driven in enough value? And two is you're choosing that initial name or branding. You have to look at whether it's confusingly similar with something else that's out there and whether or not it's too descriptive.
Yeah. I thought it was interesting. I have like Merrill Lynch Investments, right? And that's probably trademark. But what if your name is Merrill Lynch and you start an investment company? You're not allowed to use your own name, or
Most of the time you can. You're given again, that would be more of an edge case. It'd be kind of like if you wanted to start going and using the term Michael Jordan or
Mhm.
Tom Cruise or whoever.
Right.
That one, if a name or so 99% of the time you can't trademark your own a name, your own name unless it's a fanciful made up name, maybe, Harry Potter. Now maybe there's a really for most of them, you can't stop others from using their own name. Miller IP law, the term Miller is a pretty common last name. I can't trademark or stop other people. If somebody else had another last name of Miller and wanted to start a law firm, they could start Miller Law and I couldn't stop them, just like they couldn't stop me because I can't stop other people from using their name. Now, there is an exception if you have reached a level of fame where really everybody associates a given name with one individual. So Merrill Lynch, Tiger Woods, Michael Jordan, Tom Cruise, pick the famous name, Donald Trump or Kamala Harris, pick your political party, whatever you want to say. Then you can, or if you reach that level of fame to where you can really, it's still a very high or hurdle or bar to get a trademark. You have to prove that. But if you can prove it, then there's the exception to where you can have ownership of that name or for at least for particular uses or particular applications. But for the 99.9% of us out there that never reach that level of fame, you're generally not able to trademark your name just because you can't stop other people from using their name as well.
Yeah. If my name is, Mr. McDonald, can I have a hamburger store called McDonald's?
I wouldn't recommend it. So you could try, but I put it as a 99.9% chance you're going to get sued by McDonald's. But yeah, so I mean, McDonald's is another one, although technically McDonald's, the McDonald's brothers have left that very early on. It was owned by Ray Kroc, but the same thing holds true, which is everybody associate McDonald's with the restaurant. It's reached that level of fame. Everybody else, you can't trademark their name.
So what about, okay, now we have trademark, we have the R, like restricted. Is that what that means? And
Registered.
registered. Okay, and what is the difference there?
Yeah, so TM is basically just saying, hey, I haven't actually registered the trademark, I haven't applied for it, but I think I have some limited, what are called common law rights with my brand. So inherently, but if you're the first person to start using a brand, you have what are called common law rights. That basically means is you have rights for the current geographic location that you're using your brand up and until someone files for a trademark. When they file a federal trademark, you basically get to keep using it for the locations that you're currently using it, but you can't use it at any other locations, assuming you're the first person to use it and you're not, and somebody else hasn't already trademarked it or otherwise using it. So in that sense, the TM is basically saying, hey, I haven't registered a trademark. I'm using it. I think I have some common law rights to it, and it's pretty weak form. It just said, it's basically just an indication. I think I have a trademarkable term that I haven't done anything with. The R with the circle is going to be for a registered trademark, and that does mean then, hey, I've filed it with the government, I've gone through the registration process, and I have a registered trademark that is enforceable. So it's kind of a difference as to one is an actual registered trademark that has those associated rights. One is just, hey, I think I have a trademark and I'm letting you know.
Okay, interesting. So once it's registered, then it really is kind of now you own it. other people can't take it. But I would have, I thought, I thought it was reversed almost. Like trademark means it's been trademark, and R means I've registered for trademark. But so that's great to know. It's the it's opposite of that. And then you have the copyright, and what's the difference there?
There isn't. So I mean, copyright people, you can put a C with the circle there. There isn't a different or different symbol that you use for a registered copyright. Again, you have some limited rights by being the creator of material or content. You have common law rights again. If you're ever going to enforce that, whether it's in court or online or with social media platforms or YouTube or Facebook or Amazon or whatever, you do have to have it registered. So you do have inherent rights by being the creator of it. And those ones are across the U.S. or state or countrywide. But if you ever go to the point where you're going to want to do anything with it, license it, enforce it, stop others from using it, then you do have to register it. So there isn't as much of a delineation. It's just basically either way you use it, you're saying, hey, I've created, this is an original work that I created and I have ownership of it, and letting people know that it's yours and they can't simply go and knock it off or copy it.
And if there ever is a battle over that, I guess if you could produce something that shows that you had that first, you written that material in that way first, maybe you print a copy and put it in a file system with the date on it or something, or how can you protect?
That's honestly why you're typically worthwhile to get a registration. I mean, you could, if you'd have to show, it could be, hey, here's where I took the photo and it's time stamped on my computer with the file, maybe. It could be, here's where it's saved, and here's the metadata. Here's where I put it online. Here's, whatever that is. It is a higher hurdle because now the onus is on you to prove when you created it, versus if you just register it, at least by the date that you filed the registration, you can say by that date I created it because it's been filed with the federal government. So you can do it. There's a number of ways. It's really just, it's not, there isn't one definitive way. It's just going to be the onus is on you to have that great or that level of that burden of proof that you can substantiate when you created it. The other thing you have to realize with trademarks, or sorry, with copyrights, is if two people create two similar works and they each created it independently, generally, each of them has the ownership to it. So in other words, if I were to go take a picture of the Eiffel Tower, you were to go take a picture of the Eiffel Tower, we're standing in similar locations and similar lighting, we each have created a copyrightable work, but it doesn't mean I can stop other people from taking the picture of the Eiffel Tower. It simply means, hey, if somebody comes and, right clicks, copies and pastes and puts my picture on their website, then they violated my copy or my copyright. Now, if you intentionally go and try and make a material that is using someone else's or inspired by others, then you can still get into trouble. So you can't say, hey, I'm going to go take a famous, the famous painting of Mona Lisa, and I'm going to try and make my own version of Mona Lisa. You're not simply independently coming up with a work that is, of your own inspiration. You're taking someone else's work and basically mimicking it or leveraging it. Then you can't do that. But if it's independently, hey, we each created something, you do have a greater degree of latitude to coexist.
So let's say I'm getting ready to start my own carpet cleaning business or something like that. It's going to be Miller Carpet Cleaning.
Mm-hmm.
Do you think it's wise to, well, first do a trademark search, see if that's already registered, but if it hasn't been, do you think it's wise then to say, okay, let's go ahead and get this registered now before we grow? Or do you think it's worth waiting until you see how far you get and make sure that you have a good business before you go and apply for a trade? Like, what's the measuring stick to go, okay, now I should probably register this name?
Well, you gave the worst example you could as far as the mark you're going to trade. In other words, Miller is going to be a last name, and carpet cleaning is just a generic term that's describing your service, so you wouldn't be able to trademark it. But if you're to give a different example, and I can't remember, I think it's Mint is a carpet cleaner. They do some sort of cleaning out there as a brand. That one's not a last name. It's not descriptive, so we'll use that as the example. Within that, though, you would, assuming that, so you could go out and do a search. Now, searching is only as good as you have the experience in the background to do. So if you know what you're doing, go out and do a search yourself, great. A lot of times people will go do a Google search, which isn't indicative of whether or not someone's trademarked it or what rights they have. And so Google search is generally helpful to a degree, but generally you're mostly going to be looking at registered trademarks and what's out there. You'll have kind of sometimes people go out and do a search and say, well, there's another mint that's out there, but it is for corporate cleaning, and I'm doing house, residential cleaning, and so they'll say, well, I'm fine, we can both coexist. In reality, you're going to hit that confusingly similar standard of yes, but would it be reasonable that if a general consumer to see a business or carpet cleaning service that they might think that they could also offer it for residential? Probably. And so you have to balance of, how experienced you are or be able to make an assessment or determination as to whether or not it's reasonably trademarkable, or if not, you can go to an attorney that, has that background and experience. As far as, when you should pursue it, that one's kind of almost a risk tolerance. It's going to kind of go back to that ouch factor, which is, you do it earlier on. If you have a budget, I would do it earlier on, because then you're going to or you're going to more likely to secure your rights to the brand and avoid that issue. As a startup or a small business, you're going to have a limited budget. You always have more things to spend money on than you have money to spend. And so you're going to have to look and say, the longer I wait, the longer I hold it off, more likely I'll have the budget, can pursue it at some future point. But you're also taking the risk that somebody else is going to come along, file for it first, and you're going to be in a position to where you have very limited rights, or more likely you're just going to have to rebrand. And so it's one of, budgets versus risk tolerance. And there isn't a definitively right or wrong answer. It's just going to be one where, are you willing to extend that time period out with the understanding that you may have to rebrand if somebody else comes along and does the same or similar name, or if you have the budget, do it earlier.
So is it a state or like a local service? In other words, do I have to be in the same state as my trademark attorney, or can you trademark a name anywhere in the US?
And so with all three of intellectual property, patents, trademarks, copyrights, it's on the federal level. So as an example, I'm in Utah, Miller IP law, or I'm registered here. I have clients that I work with across all 50 states, if not close to it. Because it's on the federal level, you have to have a state or bar license. So you have to be a licensed attorney in a given state. But beyond that, you can help, or you can have clients or work or help anybody within the 50 states. Now, that's different if you were like divorce law or bankruptcy or something that is on the state level. Then you are restricted to, or can only do it within the state that you're licensed to practice. But for anything that's on the federal level, it's not limited to just that state.
So now what's the difference and well, obviously kind of as I say, we're going to talk about the difference because it's going to be in the question, but international versus just national trademarks. Why, when, what should you know?
So there isn't anything as such a thing as an international trademark. That'd be kind of like a worldwide trademark.
Mm-hmm.
Trademarks are on a country by country basis. So same with patents, same with copyrights. Even the huge companies that are out there, you take in Amazon or an Intel or a Ford or that. A lot of times they don't have trademarks in every possible country throughout the world because they really don't have enough of a market size to invest in there. So and I'm making it up. I have no idea if Amazon, but maybe Amazon doesn't have enough of a presence in Uganda that they're just saying, yes, we could file a trademark in Uganda, but we have 5 client or customers there. It just doesn't make sense from a practical perspective to invest in it. So you do have to, it is on a country by country basis. And so generally you're going to be looking at where is either your current customer base, or where do you anticipate or look to see where your customer base is going to be, or your market is going to be. And that's where you're going to pursue your intellectual property. So pursue a trademark or a copyright or a patent or whatnot. And so, but it is going to be on a country by country basis. There's some degree of ability to do international placeholders for primarily on the patent side for a period of time, or usually 18 months or so. But that is still a placeholder. At the end of that period, you still have to pursue it in each of the given countries. EU is the exception. Or EU, you can do it as a block, with the exception of the UK, Great Britain with Brexit. They're now treated as separate again. But the rest of the EU, you can do it across the EU with a single application. Outside of that, it's each country.
Right. So if I'm going to launch a franchise, for example, I'm going to open up a new franchise in a different country, then you want to trademark in that country, especially if you're moving into that country and want to protect that name there.
Yep. Or if you anticipate, I mean, get an example of trademark issues. Apple's a huge company. I'll give you the pop quiz, which is so what did they originally name their watch when they came out with it? It was the
Watch.
Apple Watch. Everything else was that iWatch. So iPhone,
Gotcha.
iPad, iMac. But when they got into doing the Apple Watch, and they had it or branded as the Apple Watch because there was another company that did watches that was in China that already had the trademark in China for iWatch, and they ran into that and weren't able to negotiate it or otherwise. Now they may have resolved it since then, and I haven't followed up on it. That was a number of years ago, but at least when they started, they didn't do it as an iWatch. They did it as an Apple Watch because they didn't want to have to deal with the duality of branding of it, doing the iWatch and everywhere else, and then having a separate brand for Apple Watch in China. So they simply named it as Apple Watch across the board. So that'd be one where, even a large company that has a lot of money and power still encounters that same issue of as you go to different countries, you have to work within what those countries have already been trademarked and also get your trademark if you can within that country.
So yeah, we've already talked quite a bit. Like 30 minutes kind of long, but I just have all these questions. But I'll just ask you this final one and then we'll wrap up. What if it's something along what do we do when there's something like I own a particular domain name or I want a domain name, but someone else has the domain name, even though I'm trademarked with that name? From what I understand, I still can't go force them to give me that domain name unless they bought it after I had trademarked my name. Is that correct? Or registered my name?
They can still buy it after you've registered your name and generally don't have a lot of rights. So most of the time they're separate. Me owning a domain name and you having a trademark is two separate pieces of property. You can own a trade or you can own a domain name and not have the rights to the trademark. You can have a trademark and not go or get a domain name. So you have to really operate and treat those as being separate. Now, there's a couple exceptions. If it is what's called cyber squatting, so in other words, I specifically, after you are registered the trademark, went and acquired the domain name with the basically the express intent of sitting on it and trying to make you pay an exorbitant fee or otherwise trying to make you pay, blackmail you, so to speak, to pay me for it, you do have some limited rights to that. Now, proving that is a difference. Most of these, there are some stupid people out there. Most cyber squatters are going to be smart enough to just simply say, "Hey, I own it. Make me an offer." Nope, I reject your offer. I'm not going to do it. And unless they basically come out, and I have had clients that have done it, and they make the mistake of saying, "Well, I own this." You can. They use words that incriminate themselves, so to speak, and show that they bought it really with that express intent. Unless you can show that, generally you can't force someone to give up their property, which is a URL. They purchased it, they own it, and just because you have a registered trademark doesn't mean you can make or force someone to give you their property unless they did it with that express intent. The other exception is if they are using it in a way that infringes your trademark. So in other words, so let's say we go back to Mint carpet cleaning. If you have the trademark for Mint carpet cleaning and they have the URL that then is for Mint and they start a carpet cleaning company and they brand it everywhere as, hey, we're Mint carpet cleaning, or have Mint there, when they're using it in a way that is confusing with your trademark, then you can sometimes acquire it. Still is a difficult or protracted path, but it does give you a path to it. But if they come out and they have the Mint URL and they're using it for bubblegum, you can't, just because you have the Mint trademark for carpet cleaning doesn't mean you can force them to give it to you because they own the URL, they purchased it, they're not cyber squatting, they're not using it in a way that conflicts with your trademark. Then really, they're two separate pieces of property.
Wow, that is so interesting. I remember, gosh, I don't know how long ago it was. It was a while ago, but I think Google forgot to re-register their domain name or something, and some just average guy bought it because Google had let it drop. He, I think they just based it. I think they sold him some, or they paid him like some kind of consultant fee that they would normally pay someone for something. But he was, he didn't fight him on it. I mean, he knew he'd lose. But it was interesting that they had let that go, and this guy just said, "Yeah." I think in the interview to him, he said, "I saw it was available, so I hurried and bought it before someone else did that wouldn't give it back to them," kind of thing. And so I thought that was interesting that something like
Yeah,
that
I
could
mean it
happen.
happens. You have to, most of the time, bigger or companies are going to monitor that, make sure, it's oftentimes set up on auto pay and they don't do it, but occasionally something will inadvertently slip through the cracks and then you get to probably pay more than what you otherwise would have to resolve the issue or to settle it or to otherwise deal with it. But happens on occasion, but typically, hopefully you can avoid it.
Yeah, no kidding. I mean, it would suck if another country picked that up and said, "Well, we own it now. Sorry."
Yep, that's true.
So interesting. No, well, I really appreciate your time and taking us through that and explaining the difference between all of those and how we know when we should, if we should. I think really what it comes down to is if you have questions, they just need to contact you. So, what's the best way to just to get a hold of you?
Sure. Yeah, I give a few ways, kind of depending on what or how they want to reach out. So if they want to reach out, so we offer free 15-minute consultations to kind of answer some of your initial questions, kind of walk you through things and get you started. So to do a free consultation to schedule that, you can just go to strategymeeting.com. That links to my calendar is an easy way to grab some time. If they want to connect, or well, the law firm and I think me personally probably have social media accounts set up across the board. The one that I'm generally active on or typically at is on LinkedIn. So if you want to connect up with me on LinkedIn, you can just go to meetmiller.com, and that links to my profile. The last one is if you just want to come to the website, get it. We have a ton of information. All of our flat fees are posted on the website. We have a lot of resources that are free for startups and small businesses. All of that is our general website's at lawwithmiller.com. So kind of quick run through, grab a consultations at strategymeeting.com, connect with me on LinkedIn's at meetmiller.com, and the general website is at lawwithmiller.com.
Okay, well, and I'll make sure I put those links in the description from this too, so they can get a hold of you. But I think really, it again, the best advice probably is just if you're not sure, ask.
Yep, absolutely. Grab a free consultation. If it's a simpler question, can answer or at least give you a direction as to what you might want to consider.
All right. Well, thank you so much for your time. I really appreciate that. I know I learned a lot, and I'm hoping my listeners learned a lot as well. And if you do have questions about it and you're listening to this, then reach out, go to Meet Miller and set up a appointment or strategy. What was it?
Strategymeeting.com.
Strategy.com and start getting those questions answered. So thank you again for your time. I appreciate all the taking the time to answer all those for us.
My pleasure. Thanks for having me.
All right. Thanks.